their hand off as a punishment for what they've done. But the Prophet tells us in Hadiths that no one will get their hand cut off for something stolen that's less than, usually they're translated about $25. Other Hadiths say that you won't be punished for stealing any kind of food stuff, right? And the companions, in their implementation of these rulings, would demand that the person confessed, sometimes even confessed twice to the crime, otherwise they wouldn't implement the hudud punishment. Now, this gets to the point that in the actual implementation of Islamic law in places, let's say, like Cairo in 1300 or Istanbul in 1700, of the Common Era, it was effectively impossible for these punishments to be carried out. The requirements, the evidentiary requirements, and the circumstantial requirements for these laws to be carried out were impossible and very rarely met. Well, what's the point of these laws then? Why does God mention them in the Quran? Why does the Prophet speak about them in his Hadiths? Again, we tend to think that law is just a given. We tend to think that it's a given that there's a police force, and if something happens, I call the police, and someone shows up and breaks up the fight or something like that. If something gets stolen, a cop is going to come and ask me about it, and they're going to find my car a few days later. This is not the case for most of human history. In England, there was not a police force, an official police force, until around 1830. And guess what? If you looked at English law in the late 1700s, the early 1800s, there were, I think, around 160 death penalty offenses. Around 160 death penalty offenses for things like stealing someone's silver boot buckles when they're drunk, breaking apart somebody's fish pond. I don't even know what that means. Right? Breaking apart somebody's fish. This death penalty offense? Why is this? Because guess what? There's no police force that can actually prevent this. There's nobody who's actually going to be watching to stop someone who looks suspicious, like they're going to go in and break into someone's fish pond. So the way you prevent these things is by literally scaring the crap out of them and saying, this is a death penalty offense. Do not do this. Because there's no infrastructure to prevent this. There's no infrastructure to investigate this. There's really no infrastructure to punish this. So the law codes are sort of designed to scare people. Now, so it's no coincidence that in the Sharia, there are these very harsh laws, and that they're then almost impossible to implement, because guess what? Nobody wants a society where everybody who's stolen something is walking around with one hand. Where everybody who ever is young and stupid and decides they want to go have sex with somebody is going to get stoned. Nobody wants a society like that. So what you find Muslim scholars doing, and Muslim judges in Sharia courts doing, is by making the requirements for had punishment so high, and then not having someone meet those requirements, that doesn't mean that the crime doesn't get dealt with. What it means is that it gets dealt with through something called ta'zir, and ta'zir is discretionary punishment. That means the judge deals with it according to a lesser set of punishments. Almost like dealing with each case as it comes. Okay, you've stolen something, we can't prove that you actually did, but I see that this thing is actually in your possession, and what are we going to do about this? Well, first I think you should give it back to the person, maybe you should pay them some damages, I think you are very nasty, so you should be lashed 10 times, or I'm going to make you go and carry firewood all night, or something like that. So all sorts of things that a judge could do. So just because these punishments aren't being meted out, doesn't mean they're not serving their function, which is to scare people into obeying the law. It also doesn't mean that these crimes aren't actually being dealt with by judges in Sharia courts, because they were. Okay. Now, another important point about the Sharia is that it's always coexisted with other legal systems. I mentioned to you before that a lot of times what we think about as law was missing in a lot of parts of, or a lot of communities or polities that Muslims were involved with. And the Sharia then filled those spaces. But that doesn't mean that the Sharia was always in a vacuum. It would regularly, the Sharia would regularly, and in fact I think always, coexist with basically the ruler's law, or the ruling family's law, or the law made by the dynasty that was ruled, by the state. Sometimes this was called Canon, sometimes this was called Siyasa. And here's another great example, and I'll give this to you from Ibn Battuta's travels. When he's traveling through Central Asia on his way from what's now Uzbekistan to India, he comes across this local Turkic ruler, and whenever there's a dispute, he has a council. On one side, he has 6 Sharia legal scholars. On the other side, he has some big Turkish guys with beards, elders. If the dispute involves something that religious law covers, the Sharia jurists deal with it. If it's something involving, let's say, treason, betraying his little state, something involving something that he feels a particular interest in, that he wants to influence, or that is from Turkish custom, the Turkish elders will deal with it. Now, we might sit and say, well, that's weird. I thought when you say you want the Sharia, that the Sharia has to rule everything. But that's generally not how Muslims lived. The Sharia covered certain areas of life, and the ruler's law covered other areas of life, especially things having to do with crimes involving, threats to the state. And this is, by the way, the case in every single Muslim state that I can think of, including the Ottoman Empire, which people want to talk about as this great Muslim empire. Actually, Islamic law, Sharia courts, only dealt with very specific types of issues. And the ruler's law, which was also published in big books and codified and things like that, dealt with many important areas of life. Another great example of this, by the way, was developed by a group of people who ended up ruling several provinces of what's now West Bengal, Bangladesh, and Bihar province in the mid-1700s, for the who ended up managing these provinces for the Mughal emperor. These group were the British. Right? This is very interesting. The British were actually in charge of the Sharia courts in these areas, acting as the representatives of the Mughal emperor, the Muslim emperor in Delhi. So they had to come up with a way of, as British judges and British East India Company operators, actually carrying out Sharia law there, which is very interesting. And so they developed something called Anglo-Mohammedan law, which was an attempt to come up with a more regularized version of Islamic law that British judges could implement when they dealt with Muslims. And they would use a version of Hindu law dealing with Hindu subjects. So this is another example of kind of how you have Sharia tradition coexisting with the British legal system. Today, we have exactly the same situation. Today, the Sharia, in many Muslim countries, or Muslim majority states, the Sharia coexists in various different forms with what's now usually a modern legal system. When I mean modern, it's usually either some permutation of the British common law system, like in India, or Pakistan, or Bangladesh, right? Or Nigeria, or of one of the European legal codes, modeled after the Napoleonic Code of the early 1800s, one of the European legal codes that were imported by Muslim countries after their either during colonialism or after independence. So the Turkish Republic uses the Swiss legal code. Egypt uses a mixture of the French and Belgian legal codes, right? And what you see is how does Sharia law function alongside these? Well, in Egypt, a great legal scholar trained in the European legal tradition, but also in Islamic law, named Abdurrazzaq al-Sanhuri, developed a law code for Egypt and also for Iraq that he believed took these European legal codes and made sure that no laws were there that violated what he believed were the main principles and objectives of the Islamic Sharia. In addition, areas like family law, marriage and divorce and things like that, these were governed solely by a new codified version of the Hanafi school of law and the Maliki school of law where he saw fit. So he came up with this mixed legal code that he believed is both modern in sense, also European in origin, but also true to the Sharia tradition, not only in its details on things like family law, but also in that it met, he believed, with the objectives of the Sharia tradition. And the Egyptian constitution, which I think is from 1971 or 1979, it was updated later, but the Egyptian constitution, as it exists today, and people today are always talking about, what does the Muslim Brotherhood want in Egypt? They're going to make Sharia law, put Sharia law in the constitution. The Sharia law is already in the Egyptian constitution. Article 2 of the Egyptian constitution says that Sharia law is the main source, or the principles of Sharia law. The higher aims of Sharia law are the main source of law in Egypt. Now, the way that Egyptian courts have understood this is that you cannot pass a law that contradicts the Sharia. So in theory, in Egypt, during the Mubarak era, I'm not talking about, and up until today, you cannot pass a law that contradicts the Sharia. Now, as I mentioned earlier, the Sharia is a tremendously diverse body of ideas. In Sunni Islam, you have 4 different schools of law. In each one of these schools of law, on almost every issue, there's more than one opinion. If you have it's like anybody ever have Mr. Potato Head when they were a kid? You have like the Sharia is a sort of semi-blasphemous thing to say, but the Sharia is like, you have this Mr. Potato Head, and you have a huge bag of parts that you can use to make whatever you want in the end. So it's actually very easy to find a part that fits where you can justify passing a law. If you want to pass a law, for example, that says that women cannot wear niqab and can't wear a face veil in universities, the Egyptian Supreme Constitutional Court found an interpretation of Islamic law that says this is a perfectly acceptable law to pass. If you want to pass a law that says that doctors cannot perform female circumcision, also the Egyptian courts were able to find an interpretation of Islamic law that would allow this. So the way that the Sharia coexists with these modern law codes is often through kind of a mixture of European legal systems and the Sharia legal system, and also through these what's called non-repugnancy clauses. The idea that you can't pass a law that contradicts the Sharia. As I said before, you can imagine lawyers sitting around and talking. It's very easy for some clever lawyer to find a way to show that a certain law does not contradict the Sharia. And that's why when some people say, we want Sharia law or something like that, the first thing to remember is that doesn't mean anything. That's really a statement about their identity. Do they believe that Islam is important? Do they believe that Islam is an important part of their identity? They don't want their identity to be governed by some outside idea. But when it comes to what that actually means on the ground, it's anybody's guess, because there's a million different permutations of what that could mean. And there are already today many Muslim states that have Sharia law in some kind of coexistence with other legal systems. Thanks very much.